So welcome back, dear students. Today we will be taking up the last lecture from Unit 3, that is summary of writ jurisdiction. So today we will learn regarding the summary of entire writ jurisdiction. We have already covered 5 kinds of writs available under Indian Constitution. So first of all, dear students, we must understand what is a writ. So a writ is a legal order to do or not to do something given by a court of law. If we talk about UK, where common law is applicable, so in common law, a writ is a formal written order issued by a body with administrative or judicial discretion or judicial jurisdiction. In modern usage, this body is generally known as a court. Now, dear students, you must understand the distinction between a writ and writ petition. These two words are very categorical and have a specific and different meaning, writ and writ petition. And the major difference between these two is that writ is a constitutional remedy to all people available under Article 32 before the Supreme Court or 226 before the High Courts. It is raised by a legal authority, but the petition is a form of writ raised by the people in the form of a request to a legal authority demanding an action to be taken about a particular case. So writ petition, like you draft a plaint, you draft a written statement, so you draft a writ petition also. So writ petition is a form of writ raised by the petitioner in the form of a request asking for a relief from a legal authority, demanding an action to be taken about a particular cause. So there is a distinction between writ and writ petition. The term writ refers to a formal legal document that orders a person or entity to perform or to cease to perform a specific action or deed. These documents are part of common law and are often issued after a judgment is made, giving those involved in a suit the ability to carry out the judgment. So dear students, legally speaking, a writ is an order issued by a legal authority with administrative or juridical powers, typically a court. There is another concept in our country also, and in England it is known as option D suo motu, which means on its own motion. Courts have power to issue writs on its own motion also. You must have read in the newspaper today that Supreme Court of India, then Delhi High Court, then Allahabad High Court, Madras High Court, and other high courts have taken cognizance of COVID emergency in our country on their own motion. Nobody filed a writ before the high courts or before the Supreme Court, but when there is a national emergency, so courts have taken cognizance of COVID-19 emergency on its own motion. And it is generally used when a government authority, court or an agency takes action based on their own apprehension, this is not a writ issued by Supreme Court or High Court, because it is a suo motu cognizance taken by the courts. And the importance of writs lies in creating permissible areas of exercise of power, authority, and jurisdiction over administrative actions enforced by any state. It can be said that judicial writs are constitutional remedies provided to the courts to keep the administration within the ambit of law. The administration should not go outside the ambit of law. They should confine their activities within the four corners of law. That is the main importance and function or object of the writs. So, dear students, now you must have understood the distinction between writ and a writ petition. I am repeating, a writ means an order that is issued under an authority. Therefore, a writ can be understood as a formal order issued by a court, whereas a writ petition is an application filed before a court requesting to issue a specific writ. In other words, a writ is a legal document from a court of law that tells you that you will be involved in a legal process and explains what you must do or must not do. There are 5 kinds of writs which we have already studied: habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So if I may summarize the meaning of these 5 writs, habeas corpus, a Latin word, means you may have your body or person. This writ is a protection against illegal detention. Mandamus means we command. This command may be positive as well as negative, both. Prohibition, we prohibit. Quo warranto, show your authority. If you are holding a post, say, for example, your appointment is done as Civil Judge Junior Division, but your LLB degree was not complete on the day of joining. So your appointment as Civil Judge Junior Division can be challenged under writ of quo warranto. Then comes certiorari. We quash the orders of the lower court. Then comes curative writ. If there is a defect in the order, we cure the defects in our own orders. Then lastly, review. We have the powers, court have the power to review its own decisions. Now, dear students, there was an amendment, 42nd amendment, you know, is the largest amendment in our constitution. And this 42nd amendment is known as mini constitution also. Article 226 capital A and 32 capital A were added by 42nd constitutional amendment with effect from 1st Feb 1977. And by virtue of Article 226, the constitutional validity of central laws was not to be considered by the high courts. And likewise, under Article 32 capital A, the constitutional validity of state laws was not to be tested by Supreme Court under Article 32. But these two articles, 32 capital A and 226 capital A, which were added by 42nd Constitutional Amendment Act, were repealed by 43rd Constitutional Amendment Act. So the present position of law is that Supreme Court can test the validity of central as well as state laws, and likewise high courts are also empowered to test the validity of state as well as central legislations. Dear students, we have a very important leading case before us, that is L. Chandra Kumar versus Union of India. It was held by the Supreme Court in this case that the power of judiciary over legislative action vested in the high courts under Article 226 is the basic feature of Constitution of India, and therefore it cannot be ousted or excluded even by way of Constitutional Amendment Act. Accordingly, Supreme Court declared Article 323 capital A 2D and 323 capital B 3D as unconstitutional, since these two articles excluded the jurisdiction of high courts under Article 226 and 227, and the jurisdiction was transferred to the tribunals, excluding the jurisdiction of the High Court. So this was against the basic feature of Constitution of India. So these two articles were declared unconstitutional, since they take away the power of the High Court so far as issue of writ is concerned. Now, dear students, you must understand the concept of locus standi also. Locus standi means the right to bring an action, right to be heard in a court, right to stand in a court. So locus standi means the person who has a right to bring an action. So the question is, who can apply for writs? Locus standi means the right to bring an action or to be heard in court in a matter. Otherwise, if you don't have locus standi, court will rule that plaintiff lacks standing to bring the suit, and his suit will be dismissed without consideration of the merits of the claim. So, dear students, traditionally the rule is that a person whose constitutional or legal right is infringed, he can apply for relief under Article 226. But Supreme Court has now considerably liberalized the rule of locus standi, and public spirited persons are now permitted to file writ petitions for the enforcement of constitutional and legal rights of any other person also. If that person or class of persons, if they are unable to invoke jurisdiction of the high courts or the Supreme Court due to poverty or on account of any social or economic disability. Such actions are known as class action litigation or public interest litigation or representative litigation, where the court has relaxed the rule of locus standi. Dear students, when court exercises jurisdiction in public interest matters through letters or on the basis of a newspaper reporting, it is known as epistolary jurisdiction of the court, which means acting on a letter written by or on behalf of the opposite or on behalf of the oppressed people. This strategy is adopted by Supreme Court for facilitating access to justice to the masses. And the latest example is Baba Ramdev's case regarding Ram Leela Maidan incident versus Home Secretary, where the Supreme Court took cognizance of the matter on the basis of newspaper reporting next morning. Then, dear students, we have seen that we have 5 categories of writs: HMPQC, H for habeas corpus, M for mandamus, P for prohibition, Q for quo warranto, and C for certiorari. And we have also learned that Article 32, which gives power to the Supreme Court for enforcement of fundamental rights. This jurisdiction upon Supreme Court is integral part of the basic structure of Constitution of India. And this right cannot be curtailed even by constitutional amendment. Then high courts under Article 226, they are empowered to issue writs for enforcement of fundamental rights plus other legal rights also. So whose jurisdiction is wider? Is it Supreme Court or High Court? Obviously, the jurisdiction of High Court is wider because they have power to issue writs for protection of fundamental rights as well as for protection of other legal and constitutional rights. But dear students, you must note that nature of jurisdiction under Article 32 and 226 is not appellate. Courts are not sitting as appellate court while exercising writ jurisdiction. They are sitting as supervisory courts. But please note that the Supreme Court or High Court can exercise all necessary appellate powers to do substantial justice while hearing any writ petition. And power of the Supreme Court under Article 136, that is specially petition, is purely supervisory, and this 136 power is available only to the Supreme Court, but not to the High Court. So this right conferred by Article 32 itself is a fundamental right, because it falls in the chapter, in the part 3rd of Constitution. You see, part 3rd of the Constitution starts from Article 12 and it ends at Article 35. So 32 is a part of part 3rd. 32 is a fundamental right to move to the Supreme Court. This is also known as right to constitutional remedy. So this fundamental right available under Article 32 cannot be abrogated, cannot be abridged or taken away, even by an act of Parliament. Even if Parliament amends the Constitution and tries to take away the right of constitutional remedies under Article 32, it cannot be done. If it is done by law, then the courts are there to declare such a law unconstitutional, which takes away or abridges the fundamental right available under Article 32, which is a right to ensure the constitutional remedies. You see, we have a very important leading case on this point, whether this right under Article 32 can be diminished or not. Premchand Garg versus Excise Commissioner, UP. In this case, Supreme Court struck down one of its own rule. You see, every court has its own rules. Allahabad High Court has its own rules of procedure. Delhi High Court has its own rules of procedure. Likewise, Supreme Court also have Supreme Court Rules 2013 for regulating its own procedure. So one of the rule drafted by Supreme Court itself, enacted by the Supreme Court itself, required the petitioner to furnish security as a condition precedent to the hearing of a petition. Because it imposed a financial obligation on the petitioner, and if petitioner cannot comply with it, petitioner cannot furnish cash security, financial security, then his petition would fail. And his right to move Supreme Court under Article 32 will be defeated because he cannot furnish security. So such a rule framed by the Supreme Court was struck down by the Supreme Court themselves, that such a condition that a petitioner has to furnish security as a condition precedent to the hearing of a petition, this rule is bad because it curtails the right of a petitioner under Article 32 for the enforcement of his fundamental rights. So dear students, these 5 writs under Article 32 Clause 2 had its origin in the exercise of King's prerogative power and were issued by the Court of King's Bench in England. And these powers, if you carefully see the language of Article 32, please open up your Ware Acts also. The power is to issue writs in the nature of, I have highlighted these words, in the nature of once specified in Article 32 Clause 2, but not exactly the same. Therefore, even if conditions for issue of any of the 5 writs are not fulfilled, Supreme Court may still issue writ in appropriate cases. Now take the example of Rudul Shah versus State of Bihar. What happened in this case? Mr. Rudul Shah, he was not released from jail even after 14 years of his acquittal by the competent court of law. After acquittal, release order was sent to the jailer, but he was not released for long 14 years. Supreme Court, not only in a writ of habeas corpus, released Rudul Shah from Bihar jail, but directed the state government to pay a compensation of 30,000 rupees to Rudal Shah. Now, where is the power of issuing and giving compensation of 30,000 rupees? Because this compensation is in the nature of the writ, in the nature of habeas corpus. Since you have misused habeas corpus, you have not released Rudul Shah for long 14 years after his acquittal. So this power to grant compensation is inherent in the power of habeas corpus. Because habeas corpus is a writ, the order passed is in the nature of habeas corpus, not exactly habeas corpus. Habeas corpus means you release Rudul Shah is habeas corpus. But order for payment of compensation is in the nature of habeas corpus. All right. Then we have another illustration of Vishakha versus State of Rajasthan, in which Supreme Court issued detailed guidelines for the protection of women against sexual harassment at workplaces, exercising its writ jurisdiction of mandamus. So these guidelines were in the nature of mandamus, exercising its writ jurisdiction in mandamus. I'll mention here. So the issue of detailed guidelines for the protection of women against sexual harassment at workplaces, all these directions were issued in the nature of mandamus. And so far as you have seen the jurisdiction of the Supreme Court, it is available only for the enforcement of fundamental rights conferred by Part 3. Article 32 will have no application if fundamental right is not violated. Then there is another question, we have covered it in another lecture also, whether fundamental rights are available against private individuals or not. Normal rule is that fundamental rights are to be protected by the state, and state is defined in Article 12. But where a fundamental right is also available against private individuals as a right, say for example under Article 17, abolition of untouchability, and somebody says to a scheduled caste that you will not enter my house because you are a scheduled caste. You will not draw water from my well because you are untouchable. So this right is violated by private individual. Article 23, prohibition of traffic in human beings and forced labor. If I am taking forced labor from someone, I am not paying him minimum wages. I am doing business of trafficking in human beings. So I am violating fundamental rights as a private citizen. Or Article 24, I am employing children in my factory. I am violating the fundamental rights. So in such circumstances, the Supreme Court can always be approached for appropriate remedy against violation of such rights. This was held in People's Union for Democratic Rights versus Union of India, that even fundamental rights can be enforced against private individuals also, not only against the state, but against those private individuals who are going to violate the fundamental rights. And dear students, this jurisdiction of High Court and Supreme Court is concurrent. It's not necessary that you go to the High Court first, then you will go to the Supreme Court. Jurisdiction is concurrent. But the latest trend nowadays is that if you file your writ straightway in the Supreme Court, and there are a lot many cases pending in the Supreme Court, so Supreme Court directs the petitioner to approach the High Court first. But legally speaking, their jurisdiction is concurrent. And the findings in a writ are always subject to the doctrine of res judicata. We have two leading cases, Daryao Singh versus State of UP and Gulab Chand Chote Lal Parikh versus State of Gujarat. What happened in Daryao Singh's case? The respondents objected, State of UP objected the maintainability of 6 writ petitions under Article 32 on the ground that each one of the petitioner had moved High Court for similar writs on the same facts, and the High Court had rejected them. Then Supreme Court held that writs were barred by the rule of res judicata that is section 11 CPC, and could not be entertained because you have already approached High Court. Similarly, Gulab Chand Chotelal Parikh, he was liable as surety in a loan transaction, and this was held by the Gujarat High Court in a writ jurisdiction. After losing the case, after losing the writ in the High Court of Gujarat, then Mr. Gulab Chand filed a fresh suit that he is not liable as a surety. The matter reached up to Supreme Court, and Supreme Court held that this suit was barred by the principle of res judicata, because once the matter has been heard by Gujarat High Court and it has been decided that petitioner Gulab Chand Chotelal, his liability as surety stands. So you cannot re-agitate this matter even in a regular suit. And dear students, sometimes the courts are taking this view that you have existence of alternative remedy. So having an alternative remedy is no bar to the grant of remedy under Article 32 or 226. The Supreme Court ordinarily insists that alternative remedy should be availed of unless alternative remedy is of no use to the petitioner. Truly speaking, extraordinary remedies under Article 32 and 226 should not take place of an ordinary remedy. So existence of alternative remedy is no bar for filing a remedy. So this is the detail once again of the 5 writ petition. First is habeas corpus, produce the body. Whether this habeas corpus can be suspended in India? No. By 44th Constitutional Amendment Act 1978 has provided that Article 21 relating to personal liberty cannot be suspended. Hence, the writ of habeas corpus cannot be suspended even during emergency. Mandamus, as you know, to do or not to do some specific act. Then we have certain features of mandamus which we have already covered in previous lectures also, that mandamus is a judicial remedy in the form of an order. Applicant must show that he has a legal right to compel the performance of some duty cast on the opponent. Third, no mandamus against private persons. 4, no mandamus if matter is delayed. 5th, demand and refusal necessary for mandamus. 6th, writ court is not a court of appeal. And 7th, no mandamus against legislatures. Then mandamus and ultra vires acts. And last point, no mandamus against high constitutional functionaries. Again, the 2 cases, Vishakha versus State of Rajasthan, I have just referred that Supreme Court issued detailed guidelines for protection of women against sexual harassment at workplaces, exercising its writ jurisdiction while issuing mandamus writ. Similar example is D.K. Basu versus the State of West Bengal, where the Supreme Court gave detailed guidelines for the arrest of the accused persons in a writ of mandamus. Certiorari, as you know, for quashing the orders of the lower court. Okay. Writ of certiorari issued by the Supreme Court or High Court to the subordinate courts or tribunals in the following circumstances. There are 3-4 grounds. One is when subordinate court acts without jurisdiction or by assuming jurisdiction where it does not exist. This is the first ground. Second, when the subordinate court acts in excess of its jurisdiction by way of overstepping or crossing the limit of jurisdiction. Third, when a subordinate court has acted in flagrant disregard of law or rules of procedure. And fourth, when a subordinate court acts in violation of principle of natural justice where there is no procedure specified. So a writ of certiorari can be issued. So these are the features of certiorari writ. Number 1, order of the superior court. Number 2, duty to act judicially. 3, certiorari is discretionary. 4, certiorari jurisdiction is supervisory and not appealable. And 5th feature is that High Court orders not amenable to certiorari. A writ of certiorari cannot be issued against a High Court. Yes. It is meant for subordinate courts only. Feature number 6, certiorari not for declaring an act or ordinance void or invalid. This cannot be done in certiorari. Feature number 7, no certiorari for High Court or Supreme Court. Even Supreme Court cannot issue writ of certiorari against its co-judges or minor benches, or even for the High Court. Prohibition, barring the authorities from doing something if they have done it beyond their jurisdiction or having no jurisdiction. We have an example of rural litigation and entitlement Kendra for state of UP as an example of writ of prohibition. In this case, mining in the limestone quarries in Dehradun Valley and Mussoorie Hills was stopped under writ of prohibition because it was causing imbalances in the environment. These are the features of writ of prohibition. Feature number 1, command for courts and tribunals. 2, prohibition is much common with certiorari. 3, stages when these writs can be issued. 4, where lower court has partly the jurisdiction to decide and partly it exceeds the jurisdiction. 5, prohibition effection is not permitted by law. Feature number 6, plea of alternative remedy not available while issuing writ of prohibition. And quo warranto, when a person wrongfully usurps a public office, he will have to show cause to the court under what authority he is holding the office. These are the conditions for issue of quo warranto: that office must be public, office must be substantive in character, and office must have been created by a statute. This is the most important illustration of quo warranto before you. Kumar Padma Prasad versus Union of India. In this case, Mr. K.N. Srivastava was appointed as judge of the Guwahati High Court. He was LLB, no doubt. He joined as gazetted officer in Law Department, Government of Assam in 1966. In 1985, he was appointed as Law Secretary and he worked as District Collector also, District Collector Judicial in 1987. Then he was shown to be a member of Mizoram Judicial Services and he was appointed as Judge of the High Court by the President of India. So his appointment was challenged in a petition of quo warranto on the ground that he was not qualified to be appointed as Judge of the High Court. It was held by the Supreme Court that since Mr. K.N. Srivastava was not qualified, why? He was neither an advocate of 10 years standing, nor he was a judicial officer of 10 years standing. So he was not qualified to become a High Court judge. So writ of quo warranto was issued and accordingly the appointment of Mr. K.N. Srivastava was quashed. The respondents, Union of India, they were directed not to administer oath of office of the High Court to Mr. K.N. Srivastava under Article 219. This is very good illustration of writ of quo warranto. So dear students, this is in nutshell summary of all the writs before you. So thank you very much. God bless all of you.